Hello everyone, this is Attorney Brandon here to talk a little bit about what to expect during the litigation process of a personal injury lawsuit. Now there's no two ways about it. Litigation is a lengthy, time-consuming process that can oftentimes take several months, if not years, to conclude. If your personal injury case must be litigated and goes into litigation, don't expect things to wrap up quickly. You're in it for the long haul. So let's say you've been injured due to the negligence of another person, and for whatever reason, your personal injury claim did not settle out of court. Now your attorney has informed you that you'll need to file a lawsuit in order for your case to proceed. Oftentimes, personal injury claims that don't settle do so for one of two reasons. The first reason is that you and the opposing party are unable to reach an agreement about fair compensation for the injuries and losses you suffered. The second reason is due to liability issues of who exactly is to blame for the negligent act. You say the opposing party is to blame, and they say you are to blame. If you can't reach a fair settlement or determine who is at fault, then your case will proceed to either an arbitration or a trial. The first real step in the litigation process is to file a complaint. This is done by filing the complaint in the proper jurisdiction, generally where the injury occurred. By filing a complaint, you have officially begun a lawsuit. Congratulations. Now don't be surprised to find out there's a fee for filing a lawsuit. For example, in the great state of Washington, where I practice law, the filing fee is $240. The fee tends to vary from state to state. There are likely other fees you'll have to pay as well, so be sure to check in with whatever court you're filing in before you get started. The next step is to serve a copy of the summons and complaint on the defendant. They will then have a chance to answer your complaint, either by admitting or denying liability and the damages, and provide a list of affirmative defenses. Typically, the defendant has 20 days to file an official answer to your complaint. After your complaint has been filed and the defendant has been served and responded, your lawsuit moves into the discovery phase. Discovery is one of the lengthiest parts of the litigation process, taking anywhere from 6 to 12 months. It is common for experts to be hired to provide testimony regarding the extent of your injuries and the relation to the negligent act. An expert may also opine as to the cause of the negligent act itself. Experts, it should be noted, do not come cheap, so be ready to pay a hefty fee for their time and efforts. During the discovery phase, you may feel like nothing is happening with your case, since both sides are just gathering evidence and performing depositions. But never fear. Productive work is being done, and if anything, discovery is possibly the most instrumental part of your case. So it's wise not to rush through discovery. Near the end of discovery, your lawyer and defense counsel will revisit negotiations in an attempt to reach a compromise suitable to all parties. You'd be surprised how much discovery can budge one side or another toward a potential settlement. To help with negotiations, a mediator might be brought in to act as sort of a stand-in judge, and hopefully move both sides together towards an acceptable settlement. The cost of hiring a mediator is split between both sides and deducted from your eventual settlement. If a compromise can't be reached at this point, then your case will move toward an eventual trial or arbitration. Expert discovery is when the defense hires experts to attempt to dispute your injuries. Generally, they do this by trying to show that you either had pre-existing injuries or that you aren't as injured as you claim to be. They might also hire experts to challenge the defendant's liability for your injuries and losses. These experts can have qualified opinions on topics as diverse as automotive mechanics to crash reconstruction. I've even seen cases where an economist was brought in to assess the ins and outs of a wage loss claim. Before your case can move to trial or arbitration, your lawyer and the lawyer of the defense will file motions with the court in preparation for the case they hope to make. Some of the more common motions are listed here. One good example of a motion is that of a summary judgment, which is filed by the defense and asks the court to rule that you have no case since there are no facts at issue. This basically means that they believe your case shouldn't go to a trial or that a jury will only rule against you. Motions such as these are commonly filed shortly before a case moves into its final phase. If both sides are still unable to reach an adequate settlement at this point, they will make one last go of it by having an arbitration. An arbitration is sort of a mini-trial with an unbiased attorney sitting in for a bench judge. The arbitrator will hear the evidence of the case and eventually determine an award according to the law. If either side disagrees with the verdict, then they can press on with a full-blown trial. Keep in mind, though, that if the trial reaches a verdict that is less than what the arbitrator decided, you may be on the hook for the defense's attorney's fees from the arbitration onward. This is likewise true if the defense is the one who chooses to push the case to trial. The case is then set for trial, and the judge will either issue a case schedule or hold a hearing to lay out the rules and set trial dates. Now is the time to break out your professional garb and get it to the dry cleaners. Before the trial begins, you will likely huddle with your attorney to go over your case, strategize for the trial, and get tips if you are giving testimony on the stand. A jury will be selected and the trial will begin. Jury trials typically take between 2 and 3 weeks. The best advice I can give is to give short, calm answers and to always tell the truth. Lying under oath is never a wise strategy and will only hurt you and your case at the end of the day. If the trial doesn't end how you'd hoped, it may be possible to file an appeal if questions of law were wrongly decided by the trial judge. If your appeal is successful, you get to start a new trial. The majority of personal injury cases never make it this far and usually settle out of court. But if you file a lawsuit, you should prepare yourself to go all the way to the jury. I hope this video has been informative, and I'd like to thank you for watching. If you've been injured in an accident through no fault of your own, you won't find a better law firm than the Advocates. So don't wait. Give our office a call today. You deserve an advocate.